gentlemen. Welcome to the Knowledge Group webcast, Environmental and Transactional Risk Insurance, Managing Risk and Legal Challenges in 2018. Our panel, Joseph D. Picchiotti is leader of the Environmental Law Practice Group at Harris Beach, PLLC. He focuses his legal practice on environmental regulatory counseling and litigation, as well as land use counseling and litigation. Mr. Picchiotti has substantial experience representing companies and municipalities in hazardous waste site cleanup actions, including prosecuting and defending environmental claims involving private parties and municipalities. His environmental practice includes counseling public and private companies on complying with federal and state regulatory requirements concerning storing, maintaining, and handling petroleum, hazardous substances, and hazardous wastes. His practice also includes environmental investigations, including due diligence matters undertaken pursuant to transactions, as well as drafting appropriate provisions to address the purchase and sale of assets which present potential environmental risk. Now, Joseph Picchiotti of the Environmental Law Practice Group at Harris Beach.
Thank you very much, David. And again, I want to thank Knowledge Group for making this possible to do the presentation today. And just listening to Scott's presentation from Willis Towers, it's excellent. I know Ken and Euclid and Viant from other presentations and know that will be equally well done. And so just wanted to, again, thank Knowledge Group for that. My presentation will be really focused on a particular issue, which is when a transaction is being contemplated, or when we're at the beginning of a transaction in terms of exchanging term sheets and that type of situation, you should be thinking about environmental insurance and how you should think about it and how you should move forward with it in the event that you make that decision to purchase it. Next slide. So, we do, all of the folks on the line, would appear, given the backgrounds of the companies that we saw, are pretty sophisticated, as Scott alluded to, in terms of environmental issues, presumably. Really, it's a matter of, I think, focus and some, and planning. But when you are involved in a transaction which involves, in this case, really what we're talking about are real estate, real property assets that maybe suffer from contamination concerns, and for good or bad, that is often the case, more often than not. And given the status of the law and the required due diligence to preserve certain defenses, it's an assumption really that's made. It's almost a presumption that can be rebutted by some level of due diligence. So when you're at the beginning of the transaction and you're looking at the assets, whether you're a buyer or a seller, the thought process has to be: is the real property at issue likely to be impacted in any material way by an environmental issue? And in particular, when I talk about material way in that regard, I'm thinking about circumstances where former operations have either left behind or likely left behind some kind of residual contamination in soils or groundwater. Is there a situation where, because of that, we've all seen the rise in this, and I think it's nationwide, because of residual contamination or residual contamination concerns? Is there a concern that that vapor intrusion may result from that previous contamination? And the other example I would give is where you're involved in a transaction where the purchaser is looking in some at some period of time to resell the property. Are those past operations likely to involve have a detrimental impact on the resale property, the resale value of the property? So those would be three that I can think of right off the bat that would be have the potential to have a material impact. Next slide. The other issue to keep in mind, in addition to whether or not looking at the transaction from a really basic level, whether the property associated with it will be impacted or whether there's a potential material impact from environmental issues on the property, is what are the potential liability concerns that face buyers and sellers. And again, this is a sophisticated audience, but we all know that there are state and federal laws. CERCLA is the one that comes to mind, almost instantly, which impose liability on owners and former owners and operators and former operators, depending on the circumstances, on a joint, several, and strict liability basis for investigation of the problem and cleanup of the property. And joint, several, and strict are the bywords, and simply mean that joint and several means that presumably, or at least potentially under the law, if you contributed even a small amount of waste, or there's a small amount of responsibility attributed to you as a property owner, you can be liable to clean up an entire site, even though there are other liable persons. Many of them are not available or may have other defenses. It's a strict liability basis for current owners, not past. There's some showing that has to be made in terms of past owners and operators. But for current owners, the liability is strict, which is without regard to fault. You have that obligation to do cleanup. Many federal statutes impose that. Many states do as well. The cleanup obligations on site are by governmental agencies. It's the EPA, obviously. In New York, we have the DEC, and in Pennsylvania, it's PADEP, and Ohio has its EPA, and others. In addition to those claims, there are also the potential for third-party claims, which are not limited to environmental cleanup. So if there's a site that's been, had past issues with contamination and it's been a source, and that potential source is moving off-site, then owners, current and past owners, have to be concerned about, will I face claims by third parties for both contamination that might emanate off-site, but also for personal injuries and that type of claim. I know Ken's presentation will discuss these in some more detail. There's natural resources damages, which are another kind of government claim, which goes beyond cleanup to the intrinsic value, if you will, of a resource that may have been compromised by contamination. In addition to looking at a transaction from the standpoint of the buyer and seller, what's going to materially impact that property, the other side of it is, what do I have to worry about in terms of potential liability if contamination is found? So there are required due diligence steps that a buyer must undertake in order to assert liability defenses, particularly under federal law, and they also apply under most state laws. Next slide. So the basic due diligence that is required to be undertaken prior to closing in any type of transaction involving real property is the requirement to complete a Phase 1 environmental site assessment. That is a study that's undertaken by an outside consultant. It's got to be signed by a consultant with proper credentials, and it must meet the ASTM standard. That's a standard that's adopted by those professionals. That is the law under CERCLA and under most state laws that deal with these issues. A Phase 1 environmental site assessment merely looks at, or is relegated to, previous history of the site and site operations. It does not include sampling or testing. It does include a site visit, so there are obviously visual observations made from that perspective, but it does not involve any sampling or testing. There's additionally requirements that owners, and in some cases the owners of the site or owner representatives, as well as off-site representatives, depending on the circumstances, also be interviewed and information provided. A Phase 1 ESA is required, in order for any purchaser to avail itself of certain what we call due diligence defenses under CERCLA and other law. There's the innocent purchaser defense, and then there's something called the bona fide prospective purchaser defense. As indicated, these kinds of reports are relegated to documentary evidence, and those interviews, they do not include any kind of testing. Next slide. So in the phase one process, if conditions are identified that indicate there has been a past release of some amount beyond a de minimis amount, that's what the standard says, or there's likely to be a release because of the circumstances on the property, there's tanks, there's other structures that have been compromised, then that is known as a recognized environmental condition. In general, when recognized environmental conditions are identified, there is normally a recommendation made if the consultant that has been retained to complete the phase one ESA has been asked to provide recommendations. There is normally a recommendation made to investigate that condition, which involves phase two work, which is, I discussed previously, is testing or sampling of some kind. Phase twos are undertaken in order to determine the nature and extent of the cleanup that may be required, or whether, in fact, no cleanup is required and that there's or very little is required because the release has been relatively minor release that can be dealt with quickly and easily. So again, those studies are required in order to assert those defenses. In the circumstance of the bona fide prospective purchaser defense, there is a method under the standard and under the law where even when contamination has been identified in a phase two, that the purchaser can move forward with that purchase and still enjoy some level of defense, but that defense is incumbent upon the purchaser undertaking appropriate action moving forward to address those concerns. So it's often, a continuing effort to make sure that you can avail yourself of that defense, because if you buy property or contamination has been identified, then you're going to continue to have to stay ahead and deal with that going forward, which may, as we discussed, involve incurring significant expense for further investigation and cleanup. Next slide. So, we talk about recognized environmental conditions and whether or not, and whether phase two is then recommended. But at that point, certainly in the process, if not even before your phase one is done, it's important to start thinking about, do I want to look at environmental impairment liability insurance in particular as a tool to address those concerns. There are, of course, any number of tools available to address contamination concerns on property. And again, those on the call are probably very familiar with them. Whether it's the seller providing indemnification to the buyer, adjustment or as basic as adjusting the purchase price. We talked before about a basket in terms of the self-insured retentions under Scott's presentation. We always refer to these as buckets in terms of the buyer and seller. There's a holdback in the buyer's purchase price that's set up as an escrow, and then over time, if there are issues found or if there are, as a result of build out, there are issues uncovered that require cleanup, that bucket is available to address those concerns in terms of investigation and cleanup. The one note I will say here that's really important, which we've certainly seen with a number of transactions, is if environmental impairment liability insurance is on the table as a viable, a viable option here, that really needs to be discussed and thought about early in the process, because we have seen situations where EIL coverage may be compromised or not available because you start doing phase two work, and before you know it, you've now discovered either significantly more contamination, which obviously will have an impact on the deal in any event, or you've put the market in a position where it's difficult to cover at that point because you've now all of insurance, of course, involves some level of fortuity. You've now kind of taken that element of fortuity out of it, and so you're going to have markets that perhaps are going to be less likely to be involved in that risk. So it's just something to keep in mind when looking at these coverages and looking at what's available to do that before you make a decision on any kind of extensive Phase 2 work. It may be that some Phase 2 work is appropriate in areas that are not likely to be subject to insurance, but it's something that to really think about with your not only with the broker that you're dealing with, but with your environmental consultant as you are moving through any transaction. Next slide. We talked about contractual terms, buckets or baskets, escrowed funds. Those are often, and I think Scott put it well in his presentation in terms of those can be very adversarial. They can take an awful lot of time to negotiate in terms of how much should be in the bucket, or what should the purchase price be. How much of that purchase price should be held back, and they're contentious because there's often disagreement, significant disagreement among professionals about what a particular problem is going to, how much that's going to cost to address. You have a Phase 1, you have recognized environmental conditions identified. You don't want to do too much study in Phase 2 for the reasons we discussed, and because it's going to delay the deal even more. So you sit back and you get into this debate, the buyers and sellers do, about, well, how much is this going to cost to clean up? And again, even if you set up a bucket, is for the reason Scott alluded to, that's for the seller, that's an unknown. They're sitting back saying, gee, when am I going to see my purchase price? And the buyer's saying, is there enough in the bucket? So those are, prime candidates for, and indemnifications, of course, I should say, have their own issues, for obvious reasons in terms of whether a party is going to be solvent and around to seek, pay out an indemnification should a claim be available. So in those cases, the EIL coverage can often provide and facilitate transactions, and we've certainly seen those even with smaller ones. Next, smaller transactions. Next slide. So these issues are really covered very well by Ken in his presentation for Euclid and Viant, but very basics just for purposes of our discussion. What is available in terms of EIL coverage is runs the range from on-site cleanup issues that we talked about to off-site issues, bodily injury claims for those kinds of issues, including claims by off-site parties. But I won't go into detail on those because that's Ken's presentation. Next slide. From a lawyer's perspective, the thing that I tell people all the time, and again with insurance professionals on, it's probably not all that important to you all because you know coverage better than I do. But for the client perspective, it's really important for the client to understand that EIL coverage, like a lot of coverage today, particularly professional coverage and the like, and more CGL coverage, is written on a claims made and reported form, meaning that the EIL policy is providing insurance for a identified period of time, and if the claim is not made and reported during that identified period of time, which is usually beginning with closing, and for some period of time thereafter. In the market now, and I think Ken will discuss this some more, is 10 years is the maximum that's available for this kind of coverage. And again, if the claim isn't made and reported to the carrier during that time period, there is no coverage available. The other thing is the amount of coverage, again, something Ken will discuss more, but we've certainly seen $5, $7, $10 million coverage available for transactions that we've dealt with. I just gave a quick example there because this certainly comes up in other contexts, but to bring the point home, you have coverage for a period beginning in 2017 through 2027. A claim is made in 2026, but it's not reported to the carrier until early 2028. There's no coverage for that. So that's just something to keep in mind and to be vigilant about, I should say, after the coverage is purchased and when you're addressing issues, because again, it's not a matter of late notice for coverage under these kinds of policies. It's a condition to the policy and a condition to the coverage. So if you're not, if you don't receive the claim and that's not reported during the policy period, then you're out of luck. So I'm going to talk a little bit of detail because it's important detail. Coverage is limited to the issues that are at the heart of these policies, as with any, is the insuring agreement and exclusions and conditions. And those, in the context of EIL coverage, are what we call written not only in a claims-made form and made in reported form, but also it's generally manuscript coverage, which means the terms are negotiable. You get the best price you can, but the terms are often negotiable, and that's something that I encourage all clients to do when it's, seeking this kind of coverage. You can work with your broker to do that. You can work with your consultant and your lawyer to make sure that you're getting the kind of provisions that make most sense for you based upon your use of the property and the past, the concerns, the environmental concerns that have been identified. Next slide. The other kind of basics here are that, there's generally a significant deductible self-retention that comes with these policies. The other thing to keep in mind is, and I think this has changed in the time that I've done a lot with these policies, which has been more in the last 15 years, is that they're not, one-time renewal was, at least from our experience, something that we saw carriers undertake. Now there's no guarantee, if you will, that a policy will be renewed. And that's not even related to claim history. If you have several claims, then it's not unusual for a policy not to be renewed. It's really because the market has changed, and therefore, your first policy period may be your last. And so when you're looking at the extent of coverage and what you want the coverage to do, it's something that you need to keep in mind. Again, some more detailed discussion of the nature of exclusions is going to be undertaken by Ken for Euclid and Viant. Current and prior owners may be covered by the same EIL coverage, same EIL policy, I should say. And that's, again, one of the ways that this kind of insurance can facilitate deals getting done, although I must say that the last time I looked at rep and warrant insurance, it seemed like most of it excluded environmental matters. Now that we know those are included, I think it's a great thing for transactions, and that's a good thing to know, and so I certainly learned something in that regard. It is important to know, however, if you've got both the buyer and seller as named insureds, that there's usually an exclusion, that there's always an exclusion for if there is a dispute between the buyer and seller who are named insureds. It's the insured versus insured exclusion, and it makes sense. That's why you're buying the coverage. You're going to need to deal with claims made under a policy that includes both the buyer and seller that should be dealt with contractually as well in the agreement, so that there's no, in the purchase and sale agreement, so that there's no issues later in that regard. As we discussed, they're manuscript policies. I make it a point of negotiating those things on behalf of my clients, and the way I negotiate them is I call guys like Scott and Ken, and I ask them questions to put to the underwriters. Here's my concern, how is the underwriter going to look at this? Next slide, because we talked about that a little bit in the next one.
John, just so you know, we're up to 23 minutes.
Okay, thank you. That's often a way for those negotiations to begin and to help the client understand what's covered and what isn't. and I do push hard on these issues, and it's for what you're paying for this kind of insurance, and you should do that in the client's perspective. Known contamination issues can sometimes be identified and actually expand coverage if there's a known that there were tanks, that type of thing. If those are listed as an appendix, sometimes that can actually extend the coverage. Failure to disclose those can sometimes hurt you. So that's an important thing to understand and discuss with your lawyer and your broker. The last thing I'll say on this, I think I have. Do I have one more slide? This is the last slide. I can't recall.
This is the last one.
Yeah. So the last thing I would tell you to keep in mind is when you are going out to the market and seeking quotes, I have seen situations where if there are two brokers being used, that can be problematic. I would say to find the broker with the most experience and background who understands your issues, and make sure that you're going out to market with one broker, or that will put you in a position where you're not going to get the best price or terms. Thank you very much. I appreciate it.